Roberts. Ms. Mars, if you're there, please turn on your camera. Thank you. And Mr. Mars, if you're there, please turn on your camera. Very good. Okay, so we do have both parties. We do have Ms. Roberts. Ms. Roberts, you were presenting information about credit card debt.
Yes, Your Honor. The exhibits have disappeared. One moment.
We can see them on our screen.
Oh, okay. I can't. I don't know why I can't see it.
It was. Thank you.
Oh my goodness. Let me see if I can bring it up. Can Your Honor still see it?
We can.
Okay. Yes. I'd like to draw the court's attention to Exhibit Q. This is the Apple Goldman Sachs credit card statement for respondent Anna Mars. This one's a little more complicated. This statement goes to September 30th and begins on August 31st. So it was paid in full for August. So the charges on the account up to September 15th, I believe that's a 16, were $133.10, $13.51, $41.46, $8.99, $13.51, $4.13.51. And there was a payment, let me go back to the balance. So it looks like it shows the previous total balance. There was a payment. I believe the balance at the beginning of this statement was $0. If we add together the charges, that would be $585.63. I'm sorry, it is incorrect. Looks like the balance would be actually $241.50.
Can I get that number again, Ms. Roberts?
$241.59. And I'd like to request the court to move Exhibit Q into evidence.
Mr. Mars, any objection?
There is objection. I do not believe Ms. Roberts' calculations. We do have a balance statement of $370.53 that I clearly see on statement. And I do believe that court should take this number into consideration. Thank you.
So that, again, sounds like argument contrary to what Ms. Roberts is arguing, but does not appear to be an objection to Exhibit Q, so the court is going to admit Exhibit Q at this time.
Thank you. I'd like to draw the court's attention to Exhibit R. Oh, I'm sorry. It's not Exhibit R. Oh.
Objection to this exhibit. Court was never provided any proofs of income of respondent.
That is the incorrect exhibit.
So the court is not going to address the objection until we know what exhibit she's intending to introduce.
This is Respondent's Exhibit P, which I'd like to introduce into evidence. This is a Walmart Capital One card.
Ms. Roberts, you've already admitted Exhibit P and explained this particular document.
I'm sorry. So I believe there were a grand total of 5 credit cards that would have been introduced. I'm sorry, I don't remember what we did before the break. I've marked it. I believe they're all introduced at this point in time. Bank of America 0317, Apple account 43171, Bank of America 7126, Chase 4255, Apple $25.71, and Walmart 1114.
Objection, Your Honor. Objection. Ms. Roberts does not introduce any equalization payment sheet that will summarize these numbers and will present them to court. We do not see summary. Thank you, Your Honor.
The objection's overruled. Again, that's not a legal basis for an objection. Ms. Roberts, the court agrees you provided Exhibit M, N, O, E, and Q, each of which address credit card debt. What is the total amount of credit card debt you believe, community credit card debt that you believe exists?
1 second, Your Honor. I have a total amount of debt on husband's credit cards of $1,918.50, and on wife's credit cards, $241.59. So with offset, wife would owe husband $1,676.91.
The number again, please.
67691.
Thank you.
Objection, Your Honor. Those numbers are completely fabricated and have nothing to do with community assets and debts. This number is completely irrelevant.
Right, so Mr. Mars, now is your opportunity to explain to the court what you believe that community property debt is as it relates to credit card debt.
Thank you, Your Honor. May I present?
Please.
Your Honor, please let me know when you see my screen, and please tell me what do you see on my screen.
We can see evidence 24.
Thank you, Anna. So, according to evidence 24, we do have those bank statements. Amazon credit card with balance $24.35. American Express card with balance $49. Goldman Sachs, and actually respondent's attorney presented falsified copy with wrong numbers, so the balance on Goldman Sachs in September was $3,151.78.
Objection irrelevant, that's the balance on 30th, 2022.
So the objection's overruled, but Mr. Mars, can you please show me the statement date? It's September 1st to September 30th, 2022.
Exactly.
And the actual balance is not as important as understanding when purchases were made, Mr. Mars. So do you have proof that the purchases that total $3,151.78 occurred prior to date of separation?
Your Honor, this is statement balance. This is all that I have and all it was presented with the court. I would remind that Ms. Roberts presented the same page of statement that showed different numbers exactly in this place, which is extremely suspicious. May I proceed to another one?
Sure.
Thank you, Anna. Bank of America card ending 84 with a balance total of $763.14. Bank of America card ending on 26 with total balance of $74.96. Bank of America card ending 52 with total balance of $5,594.57.
Would you show me go back please, for the Bank of America account that you have in front of us, would you please show me the dates?
Dates, yes, Your Honor. So it is
So
September
21st
yes.
through October 20th, 2022. Go ahead.
Thank you, Anna.
And actually, before you do, as you know, Mr. Mars, those dates go beyond the date of separation. So do you have any further proof within that statement that the purchases were made at the time, any time prior to date of separation up to date of separation?
Let me check later after we'll review all evidence. So this was card ending 52. I will check statements and can show it to you, but it will take some time. So if you don't mind, we will proceed and then return to this one. Is it okay?
Sure.
Thank you, Anna. So Chase Outer statement date, balance $37,405.21. This is the closest date to date of separation, the same as previous bank statement. And those payments are made once in a month, so there are no other statements. Chase Freedom, let me check dates for you. Those are September 11th, October 10th, and balance is $8,555.30. $8,555.30.
And I missed the date.
Of course, It is September 11th to October. Another is Discover card. It is September 13th to October with a total balance of $1,259. Please let me know if I'm good to proceed.
Again, for each of these,
Objection.
especially, if I may, Ms. Roberts,
Certainly.
for each of these, Mr. Mars, it would be helpful to the court if you can show when the purchases were made, because most of this covers, again, past the date of separation, which is the relevant date.
Your Honor, would you like me to file the full statements? Because I heard that you were unhappy with me filing hundreds of pages. So if you are good with that, I can file all the statements, detailed statements with the court, so you can review them, and we can probably make a continuance to another date.
So, Mr. Mars, that's not the court's request. The court's request is if you want the court to adopt your numbers, you've got to corroborate your numbers. You've got to show proof. Ms. Roberts went through her statements and showed the court when the purchases were made so that the court could assess whether they were made prior to or after date of separation. So any statement that you're going to show the court, if you want to show persuasive evidence that the other side should be responsible for that debt, you need to prove that it occurred at the date of separation or before.
Yes, Your Honor. So we have a date of September 13th. It is clearly stated on this statement. And the statement is valid for period up to date of separation, because it includes date of separation.
And the question, Mr. Mars, is do you have any proof that on September 13th, 14th, and 15th that purchases were made? And if so, would you please provide the court with which purchases were made during that time frame?
If that is a request of court, then I request continuance to prepare those statements, because they're pretty messy statements, lots of information. So I need to extract this information for you for review. Should we do a continuance?
No, sir. Today's the date for trial, especially on this account, this Discover account. We're talking about 2 days worth of purchases. If you don't have that evidence today, then let's move on to the Home Depot statement that you were showing a moment ago.
Thank you, Honor. Home Depot statement. So let me check dates. Doesn't really show. So the number, the amount is $1,597.28. Let me check where they state date for this specific statement. I'm pretty sure it was somewhere close by. But it's okay. So I do see payment due date is usually 1 month since statement, so it's most probably somewhere in September, October. I probably will have to find the detailed statement. Should we proceed to another one?
If that's your total evidence on that, sure, go ahead.
Thank you. Target card with balance of $244.83. Statement closing date is October, and it was for period of September and October. Wilshire Finance.
I'm going to object to the target as irrelevant.
Apologies, I didn't hear objection.
I didn't hear the nature of the objection, Ms. Roberts.
It's irrelevant, Your Honor. It appears to be from October.
It is okay. We can dismiss one statement from 25, so it's okay. I will not object too much.
Are you withdrawing your request on the target account, Mr. Mars?
No, I do not.
Okay, so the court's going to rule on the objection. The objection is overruled, but the court still did not see when purchases were made. And so if you have any further information on that target account, Mr. Mars, please provide it.
Thank you, Honor. I need time to provide it, so if you don't mind, we will proceed through all evidences, and then I will pull more information. Can we proceed?
Yes.
Thank you, Honor. We'll share with the statement balance of September 17th with the amount of $6,435.84.
I'm going to object as to relevance. Again, there's no proof as to what the balance was on the date of separation.
It is September 17th, and it's paid once
Do
per
not
month.
show any charges prior to that date.
The objection's overruled. Go ahead, Mr. Mars.
Thank you, Honor. Walmart statement that Ms. Roberts presented with correct balance of $338.66 per September, from August to September 22nd. So this is the same number that we have with Ms. Roberts. We'll share loan with the date of September 23rd because it is paid once per month. An amount is $5,000.
I did not catch what that is.
That is Wilshire credit. So amount is $5,042.42. With that said, let's move on to evidence 25, which presents respondent's credit card statements. Fortunately, respondent refused to provide all statements, only partial. So what do we have was, as far as I understand, already presented by Ms. Roberts. So just to confirm, so on period of September 1st to September 30, respondent had $370.53. And as far as I know, I don't have any other bank statements from respondent. Let's just double check what we do have there. So we had evidence 26 that we already reviewed with assets. And we do have evidence 27 that was also for bank statements and assets, and evidence 28 that summarizes our balances, and that clearly shows that per date of separation, September 15th, community balance was minus $67,729. Sorry, $67,729. And community.
I cannot. Mr. Mars, go on mute, please.
Of course.
And when both of you have your mics open, it's garbled. So, Ms. Roberts, what is the nature of your objection?
This document lacks foundation.
Any response, Mr. Mars?
Yes. So to make a judgment based on community assets and debts, it is required by law, and is stated in multiple resources, including such simple resources as self-help, California self-help for divorce, right? That includes that parties should provide equalization payment calculation sheet, which states clearly balance of assets and debts of party.
The objection sustained. That's not a proper response to the objection of lack of foundation. So the court is not going to consider the sheet that you had up on the screen. Any further evidence with regards to these credit card debts only?
Your Honor, objection. So far I do see that you just overruled a legal document that is named equalization payment calculation sheet that is required by law. And we do not have anything similar from respondent's side. We do have all community balances, assets, and debts summarized. We have detailed community assets and debts summarized, including petitioners' assets and debts and respondents' assets and debts. And so far, respondent didn't provide anything similar. Numbers of respondent are not supported by any legal documents except very vague statements, part of which are falsified, as was found during this hearing. And I would remind that, Your Honor, if you are dismissing legally required equalization payment calculation sheet, then I would remind you that it is most probably because you are retaliating me for personal, undeniable conflict of interest.
Objection 352 balancing. Wasted the
Yeah,
court's
so-
time, repetitive.
Ms. Roberts, thank you, but the bottom line, Mr. Mars, is the objection was lack of foundation. The court sustained that objection, and because the court sustained that objection, the court will not consider the equalization sheet that you have provided. There are ways to get evidence in, and there are ways that are impermissible. You're choosing an impermissible method to present that particular evidence.
Objection, Your Honor. If you required me to provide detailed statements, I do request a continuance to provide additional evidence that required by you.
Ms. Roberts, there was evidence presented about an American Express account. Mr. Mars, please go on mute. There's too much feedback. Ms. Roberts, there was evidence presented regarding an American Express account. That was not one of the accounts that you listed in your request. Are you acknowledging the $49 debt on American Express?
I do not have that statement, $49. If he has proof that that's what it was on the date of separation, even though that wasn't produced, I don't have that statement. I don't think that's going to make that big of a difference. Which exhibit was that, Mr. Mars?
Give me a second. So it is evidence 24 in evidence list amended 4th.
I'm sorry, I didn't catch the number.
It is evidence 24, page number 2. Your Honor, I also do have objection regarding number of assets that we discussed before break. Could you please remind me what is the number that you obliged me to pay for assets?
No, but Ms. Roberts will be preparing an order and she can provide you with the number again. Ms. Roberts, we are approaching our end of our time, so
I understand. I don't see anything on here. The statement is into October. I don't see anything here that indicates that that balance was due on the date of separation, so I would object to it.
Your Honor, I do have objection.
Ms. Roberts, what response do you have to the difference between the Goldman Sachs debt that you have alleged versus what Mr. Mars has alleged?
I believe that was the same issue, Your Honor, that it was not on the date of separation and there was no accounting as to what the debt was on the date of separation.
Objection, Your Honor. Numbers of Ms. Roberts are incorrect, and I also object regarding Ms. Roberts preparing orders after hearing, because we do have a motion to disqualify Ms. Roberts for impermissible professional misconduct. And
Ms. Roberts, Mr. Mars has also included an auto loan in his request for payment of community debt. What is your response?
My response is that the court dealt with the issue of the vehicles. That has not been taken care of because Mr. Morris has not been cooperative. And I'm not sure what his claim is regarding the automobile. In the past, he has stated he wants full price for what was paid initially during the marriage. So I would object to that.
Objection. Irrelevant. Your Honor, so Ms. Roberts is talking about cars that are separate issue, and I think we didn't go there yet. But for balance of assets and debts, community loans that include car loans are absolutely relevant and are included in equalization payment sheet and were provided as evidence, including car loans. Thank you, Honor.
Right, so at the previous hearing, the court ordered that Mr. Mars was awarded as his separate property the 2022 Hyundai Tucson without offset. For that reason, the court is going to deny the request to repay Mr. Mars the $37,405.21 towards the auto loan on the Hyundai. The court is going to grant respondent's request with regards to each of the community debts. The court finds that the evidence that was presented as to each of those credit card debts clearly show that the debt either occurred on the day of separation or prior to the date of separation, and there is sufficient evidence to support the presentation by respondent. The court, in addition, is going to add the $49 of an American Express community property debt. The court finds that that amount was clearly during the time frame of the parties' marriage, and there is no reason to believe, based on other evidence, that this was anything other than a community debt. The court is going to order that Ms. Mars pay the $1,676.91 previously requested by Ms. Mars. She's ordered to pay that to Mr. Mars, but in addition to that, she's ordered to pay 1/2 of the American Express debt. So the total payment of Ms. Mars to Mr. Mars is, the court has a calculator out, $1,701.41. The court finds that Mr. Mar.
I apologize. Would you please repeat the last number?
It was 41 cents. But do you need the full last number?
Yes.
Okay, thank you. $1,701.41. The court finds that there's insufficient reason to believe that each of the other debts listed by Mr. Mars occurred on date of separation or prior to date of separation, because there was insufficient evidence presented to show when the purchases were made, and most of the statements regarding these debts went far beyond the September 15, 2022 date of separation. And so if additional information is provided by Mr. Mars and he wishes to bring a motion for reconsideration with that additional information, the court is certainly willing to consider the additional information. But based on the information provided on this date of trial, the court is denying the remainder of the debt requests by Mr. Mars. We have exhausted our time for today, and so the court is going to set another trial date on remaining issues. The court is going to highlight the remaining issues from the last court date and from the trial briefing, the prior trial briefing, are permanent spousal support, child custody, marital status, and attorney fee attorney fee requests on both sides.
Objection, Your Honor. So child custody is bifurcated, and I do think it was stated clearly. And we have separate
Absolutely.
hearing related to custody. Thank you, Your Honor.
Ms. Roberts, the court heard Mr. Marr's objection, but the court is still going to order that you prepare the order after hearing in this case. And we are going to need to look for another date for the remainder of the trial.
Your Honor,
It
objection.
seems that a one day hearing will at a minimum be necessary.
Your Honor, objection regarding Ms. Roberts preparing orders. So we do have two consecutive
Mr. Marrs,
motions.
you've already objected. The court is overruling your objection and ordering her to prepare it.
May I stay for
I'm
record?
aware that
May
the
I stay
court
on
is
record?
aware that you have another motion to,
Disqualify Ms. Roberts for
thank you.
unprofessional and unethical conduct and pressure on witnesses and experts. Thank you, Your Honor.
Looking at February 5th as our trial date, February 5th for a one-day trial, and that would be at 9 o'clock.
Thank you, Your Honor. I would just state for the final word that you confirmed our obvious and undeniable, impermissible personal conflict of interest.
I've muted you, Mr. Marrs. We've completed our hearing February 1st at 9 a.m. Thank you, everyone.
Thank you, Your Honor.
That completes our matter.
Your Honor, did you say it was set for a one-day trial?
We've completed our matter, Madam Clerk.
Thank you, Your Honor.